afternoon. I'm Jamie Crook. I'm the Director of Litigation at the Center for Gender and Refugee Studies at UC Hastings College of the Law. I'll just tell you a little bit about our organization, give you an overview of today's panel, and then I'll turn it over to our panelists. So the Center for Gender and Refugee Studies protects the fundamental human rights of refugee women, children, LGBT individuals, and others who flee persecution in their home countries. We provide legal expertise, training, research, and publications, engage in appellate litigation and policy development, and use international human rights instruments to address the root causes of persecution and to advance human rights. So we're understandably very concerned about the regulation that we'll be talking about today. I'm also a board member of the Bay Area Lawyers Chapter for ACS. So today we'll be talking about a proposed rule issued by the Department of Homeland Security and the Department of Justice. It's no exaggeration to say that the rule would completely dismantle the US asylum system, codifying the Trump administration's contempt for refugees, especially but not only those arriving at our southern border. Today we'll hear from three panelists, and we'll make sure to save time for questions at the end. First, we'll hear from Blaine Bookey, who's the legal director at CGRS, who will give an overview of some of the most significant changes that the rule would have on those seeking asylum, withholding of removal, and protection under the Convention Against Torture. And then we'll hear from Yael Shaker, who will provide background on the legislative history and intended meanings under international and US law of many of the terms and concepts that the proposed rule seeks to upend. And finally, we'll hear from Gabriela Torres, who will talk about conditions in some of the countries with the largest numbers of people seeking protection in the United States. For short, we'll refer to those as sending countries. And she'll help us understand some of the factors that are pushing people to continue seeking protection in the United States, despite the administration's hostility and inhumane policies towards those people. As I mentioned, we'll save questions for the end, but on Zoom, you'll see a Q&A function at the bottom of your screen. And please submit your questions that way. You can submit them anytime during the panel. So if you think of one now and you don't want to lose it, you can submit it. Please do not use chat for submitting questions. It's just much easier for us to keep track of them in the Q&A function. All right, so I'll give a brief bio for Blaine and then turn it over. Blaine Bookey is the legal director at the Center for Gender and Refugee Studies, where she's worked for the last decade to advance protections for refugees. Blaine oversees the center's litigation, policy and advocacy, and technical assistance and training programs. She also chairs the board of MADRE, a global women's rights organization, and is an advisory board member for the Institute for Justice and Democracy in Haiti. ACS honored Blaine in 2016 with the David Carliner Public Interest Award, which Blaine considers a highlight of her career. So she is grateful to ACS and happy to be here. I'll turn it over to Blaine.
Yes, thank you, Jamie and ACS. Very happy to be here. And thank you to all of you for being with us to save asylum and the rule of law in the United States. So for decades, the US has served as a beacon, as a safe haven for individuals who are fleeing persecution and torture in their home countries. And US law provides for three interlocking forms of protection that Jamie mentioned: asylum, withholding of removal, and protection under the Convention Against Torture. All of these forms of protection find their roots in international treaties that have been enshrined in US law by statute and regulation. Asylum is the most protective among the three, and it permits a pathway to permanency and reunification with family, and is the hardest to revoke. It requires an individual to have a well-founded fear of persecution on account of race, religion, nationality, political opinion, or membership in a particular social group that's perpetrated by a government actor or a non-state actor that the government is unable or unwilling to control. Withholding of removal and cat protection for the non-immigration or non-asylum attorneys that are here, are overlapping in many ways. They also require a showing of a likelihood of harm, persecution, or torture, and some level of state involvement. But the burden for both of these forms of relief is higher in most respects. And this rule does touch on all three forms of relief, but we often use asylum sort of as shorthand for these. As Jamie mentioned, the Trump administration really has led an all-out assault to dismantle the asylum system. And these attacks really are the centerpiece of the administration's broader anti-immigrant objectives. And this regulation is just the latest in a long line of attempts to rewrite Congress's carefully crafted laws by executive decree. I've heard other attorneys say this, and it's true in my own practice over the last nearly 2 decades, that I can think of few, if any, clients who would make it past this rule once in effect. So again, thank you for being here. I'll just share a PowerPoint, see if this, make sure that this is working. 1 second. Okay, so I think I'm sharing my screen. So this rule really is just the latest in a long line of these cruel policies by the administration. And I want to just briefly go over these to really put this latest rule in context. And over the last 3 years, the administration has aimed to eviscerate asylum on all fronts. The efforts by the administration really fall into sort of three key aims. First is to really decrease access to asylum, to the US asylum system in the first place. They've done this through a series of policies, including metering, which really just limits the number of people that can be processed at the border each day, and forcing people to wait in line for many weeks or months before they even get the chance to present to a border official. There's the asylum cooperative agreements with Guatemala, Honduras, and El Salvador. For people who even do get processed, we're then sending people to these other countries. Guatemala is the only one that has been in effect so far, to then seek asylum in countries that are known for being the sending countries, that have very nascent asylum systems that can hardly manage large numbers and have dangerous conditions for asylum seekers. And then also the latest border closure that really under the guise or the pretext of public health have used the CDC rule to really just shut down the border and not process anyone for asylum seekers. So using public health to set aside immigration law entirely. The second of these aims is to curtail due process for those who even get the chance to make a claim for asylum. So the migrant protection protocols, forcing people to remain in Mexico while they pursue their asylum claims, where they have little access to attorneys or the ability to prepare their claims. And then finally, to restrict who qualifies for protection for anyone who actually is able to have their claim heard. There's the asylum bans that would bar anyone who entered unlawfully outside of a port of entry, or anyone who transited through a third country. And then restrictive interpretations of the refugee definition issued by the Attorney General and the Board of Immigration Appeals, our highest immigration tribunal in the US, that really restrict the definition of who is a refugee, who can qualify for asylum or these other forms of protection to such a limited extent. And this webinar really is already outdated. Already today and tomorrow will be issued, there's a new rule that will create yet another bar to asylum and withholding based on public health concerns again, that would deem asylum seekers who have come into contact with the communicable disease or come from a country where the disease is prevalent to be a danger to the security of the US. So this includes not just COVID, but other diseases as well. It's extreme, and we don't have time to go into it here, but tune back in for another webinar for how you can issue comments of opposition to that rule as well. And I just want to underscore that the policies that I just mentioned, really have dramatically reduced the ability of individuals to find protection in the U.S. The credible fear rates for people who are being processed at the border expeditiously have plummeted to just 37%. That's a 50% decline from the previous fiscal year. The merits rates for people who have their claims heard in full proceedings have plummeted to just 27%, 40% lower than the average in the previous 2 administrations. Thousands of individuals have been expelled under the CDC order, including thousands of children. More than 20,000 individuals are still waiting for their hearing in dangerous conditions in Mexico, and representation rates have also fallen significantly. And for people who are stuck in Mexico, even more dramatically. So I just wanted to share that, because given this backdrop, you might be asking, so what's left? What could this regulation possibly do that these others, haven't already done? And really this new regulation, this newest rule combines, all of the administration's tactics to eliminate access at the border, to curtail due process, to restrict the definition, really on every front, and pulling it all into one rule that codifies these interpretations of the governing statute that are really at odds with its plain text and 40 years of controlling precedents. Notably, this regulation is also silent on retroactivity and would therefore likely apply to those who are already in proceedings. And really, at its heart, what this does is ensure that asylum seekers who are able to make it through or who are already pursuing their claims in US courts are swept out as they slam the door on those who are continuing to arrive. The rule is very long and dense, and as the title of this presentation indicates, it touches on nearly every single aspect of the definition and the process, and really at each step systematically excludes yet another category of applicants, ensuring that almost no one would be able to qualify for asylum or these other forms of protections. Jamie and two other colleagues are putting on another webinar tomorrow that will go really in more depth into the rule, and we'll be putting out a practice advisory. So please stay tuned for more who want to really dig in on this. And here I just want to now provide a very brief overview of the rule for those who are thinking about filing their own comments. It will be hard for those who are to really choose from which aspects of the rule are the most affront to notions of fairness and justice. There's a lot to choose from. So in broad strokes, the regulation covers both procedural and substantive components, starting with screening procedures at the border, carrying through to the early stages of merits proceedings, and through to the final adjudication of the claims. And I would just note that the overwhelming emphasis in the proposed rule is on, quote, efficiency, but there's no balance at all with fairness and due process, first of all, and given how incredibly confusing and internally inconsistent these changes are, it's really hard to see how they promote efficiency. It might be a point you'd want to raise in any comments. So starting first with the procedural changes. So in the credible fear screenings at the border, the long and the short of it is that it heightens the burden for people and will reduce even further the ability of people to really jump this hurdle to have their claims even heard at all. Significantly, it limits the ability of people in credible fear who pass the credible fear will then be placed into asylum or withholding of removal only proceedings, meaning that they're no longer able to pursue other forms of relief. For example, T visas for people who have been trafficked. If an immigration judge reviews a negative credible fear finding made by an asylum officer who conducts the initial screening, the immigration judge now must follow the courts of appeals decisions that are binding in the jurisdiction where they're conducting the review. So for example, Texas, and not following the most favorable interpretation. A federal court in a case that we're litigating has already found that this is unlawful and really puts applicants at a disadvantage at the border when their claims could eventually be heard anywhere in the country in another more favorable location. There's several other things that the rule does as well, but turning to the merits interviews and the hearings, really where people are more in the fuller proceedings, there's sort of two key elements to the rule that are extreme and will have significant consequences for asylum seekers. The first is pre-termission. It really expands the circumstances when an immigration judge can stop the case at the early stages and not give the asylum seeker their day in court. And they can deny on this basis without having heard any testimony or even having received additional evidence in support of the claim, just a form that applicants fill out to apply for asylum. It also really expands the definition of when a claim can be determined to be frivolous, including where a claim, if it determines a claim lacks merit or it's foreclosed by existing law. And as you'll see here, it's hard to imagine where the circumstances where that would be, given just how confusing and evolving and ever-changing the standards are. But both of these things will be extremely detrimental to asylum seekers. Moving on to the substantive changes, the rule changes, makes several changes to the legal terms, the refugee definition, and eligibility requirements for torture protection. It has made changes to virtually every single aspect of the definition, and these are just a few of the highlights. For the persecution, the form of harm that you've either experienced or will experience, it defines persecution for the first time, doing away with the case-by-case fact-specific analysis, really heightening their burden by requiring it be severe, no recognition of how children experience harms or how harm should be or can be evaluated cumulatively, and it excludes certain actions from that have been recognized for decades as harms, including where death threats, where the individual isn't required to wait until the perpetrator would act on those threats. It changes the definition of a particular social group. It codifies Board of Immigration Appeals and Attorney General cases that have really constricted what a group means by adopting these very restrictive tests that are out of step with international law. And then it identifies explicitly 9 groups that it will generally not be approved, pulling away again from from a case-by-case analysis that has been really marked the jurisprudence for many decades. And it also requires applicants to explicitly delineate their, sorry, I'm just checking the chat really quick. Sorry, so I'll just move on in the interest of time. So, and then political opinion. It restricts the definition of political opinion to issues that are related to a state's political control, really aiming to exclude individuals who have opposition to gangs or other organized criminal groups, and also gender claims that have also been recognized on the political opinion basis. It also changes the nexus standard, so the causal connection that your harm is on account of one of these 5 grounds. It lists 8 specific scenarios where nexus will, quote, generally not be found, and really encourages adjudicators to deny protection in these cases, including explicitly cases involving gender-based persecution. On the issue of internal relocation, it increases the burden of proof on an applicant in cases where it's a non-government actor. In cases where it is a government actor, it's presumed that it would be unreasonable to require someone to relocate in the country. And it converts essentially this internal relocation requirement into a near universal bar for asylum seekers. And it will now be presumed reasonable where you're fleeing a non-state actor or persecutor. It also, even if you meet the eligibility requirements for asylum, it encourages adjudicators to find other reasons to deny on the basis of discretion. The rule would require that some factors be considered as significantly adverse factors, and then the other factors, if they're present, would require a denial unless the applicant were able to show exceptional and extremely unusual hardship, which is a very high standard. Several of these factors are aimed at barring individuals who have traveled through other countries en route to the United States, which is basically everyone at the southern border other than Mexicans, and also bars anyone from asylum unlawfully present in the US for more than 1 year, and any individual who fails to timely file their taxes. It just really expands the instances when a judge can deny on the basis of discretion, when historically all but the most adverse factors really should be taken into account. And then on the issue of firm resettlement, it expands the definition of when someone can be considered firmly resettled in a third country, which would bar them from receiving asylum. And then on the issue of CAT protection, Convention Against Torture protection, it really drastically alters the standards. It's not considered torture unless it's an official acting in their official capacity under the color of law, really doing away with or creating sort of this rogue official exception. In short, this regulation would gut asylum protections, jettisoning years of jurisprudence and Congress's clear intent in passing the Refugee Act to conform US law to international obligations. So thanks again for your interest and for working with us to stop this flagrant abuse of the rulemaking process. I'll turn it back over to Jamie and then look forward to more questions and discussion in the Q&A.
Okay, great. Thank you, Blaine. All right, we'll turn it over to Yael Shaker. She is a senior U.S. advocate at Refugees International in Washington, D.C., where she focuses on asylum, refugee admissions, temporary protected status, and humanitarian visas. Her most recent reports for Refugees International have been on the U.S.-Guatemala Asylum Cooperative Agreement and the CDC COVID-19 order, which eliminates access to asylum at the border. Before joining Refugees International, Yael worked on her forthcoming book about the history of asylum in the United States as a postdoctoral fellow at the Institute for Historical Studies at the University of Texas in Austin, Before that, she spent several years teaching about immigration at the University of Connecticut and volunteering at the Legal Services Office of the Connecticut Institute for Refugees and Immigrants. She has an MA in History and a PhD in American Studies from Harvard University. Thanks, Yao.
Thanks so much for having me. I'm a historian by training, as you just heard, and reading through this mammoth rule, whose lowlights were just summarized very well. I was struck by how aggressive and wrong this rule is, sort of how far back this rule takes us historically, and how opposed it is to the laws passed by Congress, bringing US law in line with international law. Because of time limitations, I'll just go over a few of the elements in the rule that stood out most starkly to me in this regard. And some of these were mentioned in the summary, and I'll go into a little bit more detail. So first and foremost probably would be the definition of persecution, which is sort of at the heart of what asylum is. And just as a background, some of you may know this, though the United States helped write the UN Convention on the Status of Refugees, which was signed in 1951, the US actually did not accede to the convention, didn't sign it at that time. The person in charge at the State Department, Louis Henkin, whose work some of you probably know, claimed that the non-refoulement provision, the provision in Article 33 of the convention, the fundamental provision that you cannot return somebody to persecution, to a place where their life and liberty would be threatened, was not something that the United States really had to deal with because it was, quote, not so geographically situated as to receive many illegal entrants. Well, this is all about that. We are now way beyond that. And that wasn't true then, and it's certainly not true now. What we had instead in the 1950s and 1960s in the US law was a provision that said that the Attorney General could withhold deportation of anyone in the country who would be subject to physical persecution, in the opinion of the Attorney General, if sent back to their home country. Now, in the 1950s, this was an extremely high standard to meet, that physical persecution standard, and lots of people couldn't meet it, even if they were from communist countries where they had been targeted directly. In 1962, for example, the Board of Immigration Appeals rejected the withholding of a man from Yugoslavia who had been recognized as a refugee by UNHCR. The definition of physical persecution at the time was torture, very long imprisonment, denial of all means to earn a livelihood. In 1965, even before the US acceded to the Refugee Convention, the definition for this withholding standard was expanded a bit to include persecution beyond the physical, to be persecution on account of race, religion, or political opinion. And then in 1980, the US acceded to the UN Convention in 1968, and then in 1980, the Refugee Act actually incorporated the UN definition of what a refugee is on those 5 grounds that was discussed earlier. That persecution definition became part of our law. And I just wanted to emphasize what this rule does, this rule that we're talking about now, this regulation, it basically defines persecution as, quote, an extreme concept of a severe level of harm that would constitute an exigent threat. So it's almost like we're going back to the physical persecution standard that we had in the 1950s, like long before even 65, let alone 1980. And as was mentioned before, repeated death threats, repeated detentions, and persecutory laws on the books in the country where a person is from would not count as proof of persecution. So I think even the 1965 standard recognizes that some forms of persecution that were, say, economic could count because they were clearly connected to political persecution in some way, so like on a communist country, for example. The narrowness of the term political in this rule, and this is also brought up before, is absolutely astounding. The only thing that would count would be if you were targeted for supporting like regime change in the country that you're from. No other kind of political activity would really count if you were targeted for that. You know, one of the most important developments of the 1960s and 1970s in this country, in the United States, was actually expanding what we think of as political, especially when it comes to gender and gender-based violence, and more, I'll speak more on that later. So this rule really takes us back to the era, not just before 1980, but before the 1960s. I would actually argue that the definition of persecution in this rule is narrower than a persecution exception that was carved into the 1917 immigration law, even, you know, at the beginning of the century, at a time I was not very progressive on immigration matters, when there was an exception where people who could prove that they had been persecuted or that they were trying to enter the United States because they had suffered religious persecution in the country of their last permanent residence, whether that persecution was evidenced by overt acts or by laws or by government regulations that discriminated against them, they would be, you know, considered refugees basically and allowed to be admitted. So that 1917 law, you know, said if there was a law on the books that persecuted you in your home country and you could show it, you know, you're in. I mean, we're really, really going backwards. The second point I wanted to make has to do with that notion that in that 1917 exception where it said that, you know, the persecution was in the country of your last permanent residence. And this gets to the issue of being firmly resettled that was mentioned earlier, and the bars on that. You know, especially folks who are tuning in from California may have heard that the Ninth Circuit recently ruled illegal the third country transit ban, basically making those who pass through a third country without asking for asylum there ineligible for asylum. There is literally no basis for that transit, you know, ban, third country transit ban in US tradition or law. All of the post-World War II laws regarding refugee resettlement from overseas provided that if you could qualify for resettlement unless you had found firm resettlement or you had been placed firmly in another country. You know, if you were in transit somewhere, that wouldn't necessarily bar you from resettlement in the United States. Then this was incorporated into the asylum law and reaffirmed in the 1996 law. The current rule is an extreme example of, you know, the many ways that the administration is trying to, as was pointed out earlier, basically externalize its obligation to protect and send people to places, you know, if they get to our border, send them to places where they won't be safe and they won't be secure. They won't have status, they won't have work, necessarily have access to work, housing, or be united with their families. This is truly extreme, and basically it's based on the idea that if you've transited through a third country and you didn't stop there, regardless of whether or not you would be safe there or you'd get any status there or be able to support yourself there or have a housing there, your claim is frivolous, which is basically, you know, the Ninth Circuit found that absurd, but that's basically the premise of these transit rules. This gets me to this, you know, frivolousness that was mentioned. You know, I would be the last person to tell you that the 1996 law, IRA, was about welcoming asylum seekers into the United States. The assumption of the members of Congress primarily responsible for drafting that law was that the asylum system was being abused. But advocates for asylum seekers at the time, working particularly on the Senate side, really pushed for safeguards and a more lenient standard at that credible fear stage, that initial entry stage, that entry screening stage for asylum seekers, so that they would get a chance, people who arrived traumatized, didn't speak English, didn't have attorneys, you know, they would get a chance, if they passed a very lenient bar, they could get a chance to actually had their day in court before an immigration judge and explain why they merited asylum. I mean, the idea was you didn't want bona fide refugees to really get stopped at that initial stage. And you know, this is attested to in the conference reports in the 1996 law by Senator Hatch, who basically came out and said this. So the credible fear standard was supposed to be lenient, and this rule really just goes completely in the opposite direction. And the last thing I want to say, because I'm running out of time, has to do with defining particular social group and the nexus that was talked about earlier. You know, the Refugee Convention did not define what particular social group meant, but what was clear, if you read the preparatory documents and the writing of the Refugee Convention, it was supposed to be capacious. It was basically supposed to encompass the persecution that existed at the time that was not covered by any of the other political, religious, you know, race, any of the other four grounds that were more specific and more clear in the convention. And what, you know, has developed since the 1980s, a particular social group sort of reflects the changing nature of persecution and its agency over time. And, you know, the idea that you could sort of pre-termit the applications early on just by reading the paper would certainly stop like the evolution of the law and how the law has developed over time. I mean, and to say that, you know, an application for asylum is frivolous if it doesn't meet the legal standard, when the whole point is that the legal standard evolves over time, makes absolutely no sense. I mean, it's a very closed view of what this standard really means. It was intended to evolve, you know, and, you know, this was clear because from the 1990s through the 2010s, you know, in terms of how gender-based violence and domestic violence was increasingly recognized as, you know, a possible, in different forms, a particular social group grounds for asylum. And Congress recognized this. At one point, DHS actually published, it was Department of Justice, before DHS existed, it was in 2000, published regulations that really emphasized this. It was about to come out, you know, that basically said that domestic violence could be considered. There were congressional hearings about that. The Board of Immigration Appeals has ruled on this already. And so what this rule is really doing, as I said, is sort of bringing us back to at least on particular social group and nexus issues, it's really bringing us back to, you know, the early 1980s again, and thinking about how we would evolve this persecution standard to kind of, to be what the persecution that people were fleeing actually is. And, you know, UNHCR has, as was mentioned earlier, recognized that people fleeing gang violence, people fleeing gender-based violence, UNHCR has recognized that as refugees, that is persecution. So I'll leave it there. There's so much more I could say, but thanks so much for tuning in. And I mean, there's so many ways in which you might engage and comment on the elements in this.
Okay, great. Thank you so much, Yael. We'll introduce Gabriela Torres next. She's a PhD anthropologist with more than 20 years experience working in academic environments in Canada, Latin America, and the United States. She is a professor of anthropology and the co-coordinator of the public health program and co-director of the Center for Collaborative Teaching and Learning at Wheaton College in Massachusetts. She currently serves as ombudsperson for sexual harassment and sexual assault for the American Anthropological Association, and is in the anti-racist and social justice seat of the association's members, programmatic advisory and advocacy committee. Torres is also past president of the New England Council of Latin American Studies. As a researcher, she has focused her work on the study of sexual violence and feminisms as these relate to law and politics. Her work is published regularly in Anthropology News, and she has been featured in the Los Angeles Times and the Providence Journal. Her knowledge on gender-based violence has been sought as expert testimony in asylum and criminal courts in the US and Canada over 70 times. Okay, thank you.
Hi. So I'm going to just share my screen briefly at the beginning, just so that you get a sense as to a little bit of the geography, and I hope that you can see this as part of the larger screen, but if not, at least you get a sense as to what I'm talking about. So today I'm going to talk about why people seek asylum in the US from the Northern Triangle. And the Northern Triangle we defined as Guatemala, El Salvador, and Honduras. And the question is really, why do they come? If there are so many bars to asylum, why do they come? I think the short answer to this question is simply that the region is in crisis, economic, social, political crisis, and such circumstances always create refugee flows. Describing what makes a refugee is another way to talk about what migration scholars call push factors. And so that's what I'm going to call them today. What we do have to keep in mind is that push factors for making refugees have to be extreme. And so here's what I plan to talk to you about. I want to talk about the unserviceable levels of corruption and conflict. And this is actually a really complicated thing that we can't really get into in a deep way. I want to talk about structural inequalities, of which gender-based is one example, but that's the one that I'm going to focus on. And I want to talk to you about how country conditions are changing for the worse. And I think this is where I will stop sharing and actually just talk to you face to face. So while I will be speaking generally about the region, I'm actually going to focus specifically on Guatemala so that we can get a little bit deeper. The region is in active conflict, and this conflict has been persistent but changing in nature over the past 50 years. Unlike other conflicts, the Northern Triangle conflict doesn't have an easy bad guys, such as the transnational illicit political economic networks that we sometimes call gangs, like MS-13 or Calle 18. These are one expression of the illicit political economic networks that are working in these countries. I want to reiterate that while gangs are players in the current conflicts, it's incorrect to reduce the Northern Triangle problems to gangs. It's true that they're endemic in all three countries, but to think about what's happening here as gang is to underestimate it in a significant way. For instance, in Guatemala, where the UN-sponsored anti-corruption commission functioned until last year, the commission, when it was disbanded by the Guatemalan government, noted in its final report that Guatemalan institutions are fully co-opted, and I quote, fully co-opted, and that the country is now controlled by illicit political economic networks that have successfully captured the state. Because political parties have been funded, and this is all political parties have been funded by these criminal networks, the ideological persuasion and or the nominal head of state and his party matters very little. All political parties are indebted. This is the fact that while, sorry, I was just checking the chat. The fact that while state is fully involved in the illicit political networks is an extreme push factor, because while populations are routinely extorted, threatened, and persecuted, raped, and killed when they resist these networks, the state is complexly complicit. Police are not a reliable option for seeking relief, and neither are courts. And this has been found in Guatemala, where there actually, in the three countries, is one where there's actually been an independent commission that's looking at impunity and corruption. And in Guatemala, what this commission has found is that police have tampered with the evidence and sidelined investigations, that specific judgments and the selection of judges have been bought for, and that the corruption is part of the justice system and the prison system as well. So what you can see is that when we talk about the criminal networks, we're not really talking about something that's so separate from the Guatemalan state. This has meant that Guatemala has been defined as one of the most corrupt countries in the world. And this is a push factor, right? When you get populations that are being targeted, and they have no recourse in an unwilling or unable state. There's also the entrenched inequalities. So the Northern Triangle suffers from numerous entrenched inequalities that are part of the culture and the institutions of the countries of Guatemala, Honduras, and El Salvador. Importantly, there's no consistent access to the basics. So there's no consistent access to food, housing, health, education for the majority of the population. Unemployment and particularly underemployment are rampant. In El Salvador, for instance, the under and unemployment are 50%. In Guatemala, the unemployment rate is low, but the people who are employed, 70% of them actually work for the informal sector. And informal sector has very few jobs that are actually full employment, and it's very susceptible to changes in the economy. As a result, Guatemala has 60% of the people living under the poverty line. So the reason for lack of employment and lack of access to key services is linked to the problems of governance that I've talked about and I mentioned earlier. One form of structural inequality that I want to focus on in the Northern Triangle is something that has become infamous for, and that's gender-based violence. So for example, let's take femicide. So femicide, some of you might know and some of you might not know, is the socially supported killing of women. And this is reached epidemic proportions in Guatemala and El Salvador and also Honduras. Based on the figures from the National Institute of Forensic Sciences in Guatemala, from 2000 to 2018, approximately 12,000 women and girls have been brutally murdered because of their gender. Guatemala infamously has the highest rate of femicide in the world, with El Salvador being higher. In fact, according to the UN, Guatemala ranks amongst the countries with the highest rate of violent deaths among women, and that is 10 per 100,000, which is very high. According to the data from the Guatemalan Ombudsman for Human Rights and the Ministry for Public Affairs, there are actually no departments, and departments in Guatemala are like states. So there's no part of the Guatemalan territory that are exempt from gender-based violence. When the United Nations Office on Drugs, Crime, and did a study on gender-related killings of Guatemalan women and girls, the high rates of femicide they found to be the worst expression of unchecked rates of domestic and gender-based violence. So let's talk a little bit about why these exist. So many societal factors contribute to the prevalence of gender-based violence in Guatemala. So let me give you 5. So the first is that sexual violence against women and girls became normalized during the Guatemalan Civil War, which took place between 1978 and 85, but only resolved in the late 90s. So the practice of sexually assaulting women and girls and publicly displaying their bodies has continued until today. Second, poverty, economic dislocation, urban migration have disrupted historical notions of the family, and community ties have been taken apart. So things that might have functioned within the culture to stop violence against women have been disrupted. Third, in the public discourse, violence against women has become an accepted cultural fact. It is not uncommon for people to drive within Guatemala and try to avoid the bodies that have been left around by men who have killed them, and by police who do very little to actually seek out who's actually done it. Fourth, the interests of Guatemalan women are not represented within the Guatemalan government, and there's a lack of political will to combat violence against women. And fifth, the tradition and cultures and stereotypes that Guatemalans hold dear trap them into subservience. And so these are the 5 sort of key reasons. And adding to all of this is the state's implicit and explicit support for gender-based violence by their unwillingness, or perhaps inability, to hold those who perpetrate violations against women consistently responsible. High rates of gender-based violence such as this are a huge push factor, especially if we stop to think about how these are felt by individual women. think about how you can't find relief when you're beaten, how when in cases that I've worked with women, they go to the police and their abusers are called to come and pick them up, where they're told to go back and make up with the man who just cut them, where the police tells the woman that if she complains, her situation is going to get worse, and it's probably going to be a danger to your life. So this is what people live, and this is what pushes them out. Let me move to recent changes in the country conditions, and this is actually becoming a lot more important given what Blaine shared with us at the beginning around impending changes for public health reasons. So COVID-19 pandemic has made the situation in Guatemala and in Central America generally much worse. And this has created particular dangers for deportees that have been sent to Guatemala as a safe third country. This has been happening in Guatemala throughout the whole pandemic. As it struggles with the onslaught of COVID-19 positive persons, Guatemala's health and public services system is under threat of collapse. Currently, there are an estimated 1.5 million people that are in need of food aid to survive, as stay-at-home restrictions have combined with seasonal drought and exceptionally high rates of underemployment. In terms of health provision, the country has what the Pan American Health Organization calls a politically constrained, unequal and fragmented health system that is unable to adequately address the complex health inequities that Guatemalans face. As an example, the country has 0.97 doctors per 100,000, only 40% of which can actually service the general public. It has only 2 fully outfitted urban hospitals, and while an additional set of facilities are being built to deal with the growing number of cases, staffing is also a problem. In Guatemala, there are only 33 pulmonologists and 769 internists, which are the kinds of doctors that you actually need to deal with COVID-19. This seriously constrains the country's abilities to deal with patients. As a result of the pandemic restrictions and the impact it's had on frontline services providers, women are particularly worse off than they were before. And so let me turn to this. In the months of May and June in 2020, there were an average of 6 calls for help to police per hour in each day for domestic violence harm, as well as an increase in women committing suicide. The Attorney General also reports that an average of 3 women per day were disappearing during the pandemic quarantine. The conditions in COVID-19 dedicated hospitals are also putting women at risk for sexual violence, as the most recent firing of a hospital director for a COVID-19 hospital shows, where he was fired because of sexually assaulted women who were in the hospital. Deportees have also been really badly affected by COVID-19. So deportees to Guatemala have become an identifiable group. They were already vulnerable populations to begin with, but they've now become vulnerable to violence upon their return in the country. To begin with, the processes of detention and deportation have exposed them to the transmission of the virus. In May 2020, a study found that 70% of detainees could be infected by day 90 of detention if crowded conditions within detention centers remained unchanged. Guatemalans know all too well that deportees pose a risk to the general population, and this makes them very vulnerable. To date, 20% of all Guatemalan cases of COVID-19 consist of infected deportees, people who were sent back from the United States to Guatemala who have spread COVID-19. Even though deportees have always had threats and stigma, this is now worsened with COVID-19, given the fear of contagion. And communities across Guatemala are refusing to have deportees in their midst, even if they've tested negative for COVID-19. Deportees have now been threatened with lynching and burning wherever they might seek to resettle. And while flights of deportees were stopped for several weeks in the month of May, they now have resumed. And the latest flights that have been sent back to Guatemala have continued to have individuals in them who have been infected with COVID-19. And so this is the situation that we have in Guatemala that makes people push out and try to seek asylum in the US, even when they actually know that the conditions of them getting asylum are really limited. And that's what I wanted to share with you today.
Okay, great. Thank you so much, Gabriela, and thank you to everyone. I'm just going to talk a little bit about the rulemaking process and the timeline that we might expect, although there's really no way to know, and some opportunities to comment, and we'll send that information to you in a follow-up email as well, and then we'll have some time for question and answers. So I've already had some questions submitted. Please keep them coming, and we'll have a chance to talk with everybody a little bit more. So I think this might have been addressed already in a typed answer, but just so everyone has it, the comment period on the proposed rule ends on July 15th. The more comments the agencies get, the more they have to review. They are actually required to review every unique comment. If they get 1,000 copies of the exact same comment, they don't have to review 1,000 copies, so they have ways of telling what's unique. But there are many templates that you can use to submit your own comment, and we'll strongly encourage you to do that, and you'll receive a follow-up email from ACS with some links that you can use. They can be as short or as long as you like, so it's really helpful to submit more comments. It's just more the agency has to process and respond to when it finally issues the final rule. This rule is unusual. Often proposed rules have a 60-day comment period, particularly one as significant as this one. The agencies have given it a 30-day period, which has been the subject of challenge, but there's no indication they're going to change the date. So July 15th is the date. After that, the agency has to take time to review the comments, to issue a final rule that includes its reasoning for how it responded or rejected the different comments. There's really no way to know how long that would take. In an ordinary situation, a rule this significant could take months and months and months. However, this administration is facing an election, and there's reason to think they'll try to do this as quickly as possible. So exactly how long that will be, who knows? The less time the agencies take to issue a final rule, the more vulnerable they'll be to a challenge under the Administrative Procedure Act, because they will have a harder time showing that they meaningfully engaged with all of the comments. So it'll, we'll see how they respond to that. But there will be a final rule issued, and once the final rule is issued, it will take effect most likely 30 days after publication. There are different rules on how long the effective period needs to be. The agency has said in the proposed rule that it does not consider this to be a major or significant rule requiring a 60-day comment period. That'll be another subject of challenge, almost certainly, but they have been signaling that they will give it a 30-day effective period. So what happens between the publication of the final rule and the effective period is most likely there will be lawsuits challenging the rule under the APA and the Constitution. There'll be much more information about that whenever we get to that point, but that's kind of what we're looking at. We don't know when the final rule will come out. Once it does, there'll be at least a month before it goes into effect, and there will almost certainly be some legal challenges to the rule. We have some questions about what the rule could mean for people who already have pending asylum cases, and we'll talk a little bit about that. I will just say one more thing about the rulemaking process, because we are nearing the end of the administration and a new Congress coming in January, is there's a possibility of reversal by the Congressional Review Act. And so that allows a new Congress to reconsider regulations that were finalized within the previous 60 legislative days. There's no way to know exactly when that look back period is until we know whatever the last legislative day was in 2020. However, if the rule is not finalized until a date within that 60-day look back period, a new Congress could reverse the rule if it's not already enjoined through legal challenges. All right, let's go to questions in the queue. And maybe we have a couple, and maybe I'll start with Blaine. Thoughts on those of us with current clients with pending asylum proceedings? First question is, are there any conflicts for such attorneys to present comments? So if there's a pending asylum case, can that attorney or that client submit a comment?
I don't see any potential conflict of submitting a comment on how you think this rule is unlawful and immoral, or just, you know, just a wrong approach. So I don't see any potential conflict. I don't know if my other panelists disagree, but I would, yes, I think if you have something to say about the rule, that you should comment. And then in terms of pending cases, I think that, you know, I mentioned that the rule doesn't say anything about how it would apply retroactively, and this is a very sort of, you know, complicated area. And, you know, I think there are strong arguments for why at least some portions of the rule should not apply retroactively, but most likely that would be something that have to end up being litigated.
Okay, another question is whether Biden's team have spoken about this.
Oh, I'll send his statement on World Refugee Day. He did mention something about it. I'll forward a link to it. And I think I don't know if he's also tweeted about this too, but his statement on World Refugee Day has been pretty, and there's at least some subcomponents of this rule that in his immigration plan, he has explicitly said he would overrule, like restoring protections for people fleeing domestic violence, for example, is something that he has already committed to after the Attorney General's decision on this a couple of years ago. But so there's all these various subcomponents that we've seen over the last few years that are then rearing their heads again in this rule that I think his commitments on those issues would hopefully also cover.
So there's an empty question queue for people to fill in. But while we're waiting, I thought actually it might be good to hear from Yael on the COVID-19 border closure and how that is currently affecting asylum seekers, and anything about the new public health bar regulation that we just received news of today.
Right, thanks. You know, Gabrielle talked a little bit about this too, because in terms of the deportations, so the rule from March was the CDC basically put out an order that under sort of a public health authority that there's this old regulation from the 40s, public health rule that basically said that gave the president or the Department of Health the ability to sort of stop the entry of anyone into the country who would pose a public health threat. The CDC basically said, okay, well, there's a public health emergency going on, and anybody who shows up at the border or has already entered the border and doesn't have papers, who's caught by the Border Patrol or presents at a port of entry, doesn't have papers, can basically be summarily expelled under this. And there's already been litigation against this, because not only, and also I should say, not only does this sort of, and there was a couple of days after the order was came out and the rule came out, there was ProPublica published like the guidance that the Border Patrol is actually using to screen people, and you know, they're really not given the required asylum protection screenings. At most, there may be, I mean, they have to like affirmatively say whether or not, you know, if that they fear something, and even then they're not really given a chance to apply for asylum. The statistics are that I think 4 people since March have been allowed to apply for asylum. So basically everybody's getting expelled or deported, depending on Mexico has agreed to take Central Americans, not unaccompanied minors though, which is why a lot of unaccompanied minors are actually being directly deported to Central America, like Guatemala, for example, or Honduras. And the litigation that has contested this was actually on behalf of these children, and saying that, you know, the CDC order and this policy of expulsion of the border on the basis of public health not only is a violation of the Refugee Act and asylum obligations, but also a violation of the Trafficking Victims Protection Reauthorization Act, because it doesn't really screen kids for trafficking, and it doesn't provide them the ability to apply for asylum. In some ways, it's similar to the way that the current asylum rule that we've been talking about today, you know, puts people in these asylum only hearings that Blaine mentioned, like, rather than allowing them to apply for other forms of relief, like under the TVPRA or special immigrant and juvenile status visas. All those forms of relief that Congress actually created for people are not, you know, under these rules, it cannot be accessed. You know, we cannot access these protections. The recent rule that came out, it was, you know, came out today, it's actually going to be published in the Register tomorrow. There is, both in the asylum law and in the law regarding withholding, which is the, you know, helps us adhere to the non-refoulement obligation I talked about before, there is an exception for people who pose a danger to the United States. So, but, you know, usually the way that's done is individualized assessment. You cannot deny somebody access to asylum or refoul them to their home country unless you do an assessment that they are in fact a danger to the security of the United States. And this has always been like a sort of it's a national security bar. This usually applies to like terrorists in the past. What the rule to this morning does is basically say that the public health, the pandemic that we're now in, poses a national security risk to the United States. And so it defines danger very capaciously. It also, it says that although, you know, Congress had defined this concept of danger in national security terms, you know, it also incorporated like economic harms to the United States. And therefore, since the pandemic also poses an economic harm to the United States, therefore, somehow we can, you know, characterize this not just as a public health crisis, but as a national security crisis that threatens and endangers the United States on security grounds and on economic grounds. But what this also does, what the rule does, and I think is the most important thing to me about it, is that it basically says that if you've, you know, rather than do those individualized assessments of who poses a danger and therefore, you know, can be expelled or it can be barred from asylum based on the fact that they pose a danger, it doesn't do that individualized assessment. It basically says, you know, we're going to define danger as anybody who has transited through a country where COVID is. So you don't actually have to have symptoms. You don't actually have to be sick. You just have to have, transited through a place. It's basically barring anybody coming from any other country, from asylum and from withholding of persecution, where, you know, where the CDC has said that there's a, you know, public health risk there. So what this really does again is, and I think to me, what's startling about this too, is that not only is, you know, an additional bar against asylum, which kind of intersects weirdly with the current rule that we're talking about, so the details will have to be worked out, but it also is basically a bar on, it's basically saying we don't have to abide by the non-refoulement obligation, the withholding obligation either. We just send people back. So it's really, to me, it's just like throwing the UN convention out the window. But anyway, so that's that. So yes, we should write comments on that one too.
Look out for more webinars, as Blaine said. And I think in that regard, you know, it really sets the United States apart from many other developed countries that have specifically allowed for asylum claims to continue to be made during the pandemic. We're really an outlier there. No one has, some countries have shut off the border, but not the countries we would like to consider to be our allies and our partners. Actually wanted to turn to Gabriela. One question was, is there a place where we can find citations for the information you're providing? And Blaine provided a response, but just to make sure everyone has it, on the CGRS website, There's a technical assistance page where you can request assistance and have access to country conditions information from many experts, including Gabriela. So I will send that link in the follow-up email that we'll be sending out if people are interested in more citations and those facts for country conditions information for your cases. Gabriela, I was wondering, one of the changes that Blaine talked about was the change to the definition of torture to increase the requirements for showing official state action. So it's you will now have to show that a state official acting in his or her official capacity was somehow involved in the torture, either actively involved or actively omitting their duties. And I was wondering if in the case of domestic violence in Guatemala and the Northern Triangle, how you would see that playing out, if you think it would be harder to show state action given the sort of lack of response when people do call for the police.
Sorry, technical issues. I think that's always hard to show. And it's particularly hard to show inaction when, let's say, an order is issued, but there's like a restraining order might be issued, and there is no intention of actually making it effective, which is usually the case in Guatemala. So even if you get past the bar of the police, right? How do you have proof that you even went to the police beyond what you yourself say? And in some cases, I've seen that people, well, can you show us the filing? And well, the police didn't give me a filing. And so it's very hard for people to prove to begin with. So I really don't know how people would be able to make those claims of gender-based violence and also prove to the standard required that the state was actively involved. That's what I would say, and I don't know if Blaine might have other thoughts, but I think from the expert, often we're asked even now for things that actually don't happen in Guatemala as proof. And so I think that would only get worse in the case of the expert.
Gabriela, one more question I thought of for you is, how much information do people have in countries like Guatemala about what's going on with asylum rules in the United States before they come? Like, is there a general knowledge that the administration is cracking down and making it harder, that the border's closed?
Yeah, so there most certainly is general knowledge. This is something that's covered in the newspapers. It's also covered by the international Spanish-speaking media. And it's covered in terms of the discrimination that's happening, the way that people are dying in detention, the way that people are being deported to Mexico and left in these danger zones at the Mexican border, how people now have become prey to kidnappings in Mexico is also covered. So there's a lot that's covered in the media, but the problem is people are between death and death, right? That's actually what people are. This is what a refugee situation looks like, right? People are between death and death. So they are fleeing because they can't see a possibility of a viable life where they're at, even if they see that it's not going to be easy. Their life isn't easy right now. So I think so there is general understanding. There might not be understandings of the specifics of the laws. There is also general understanding of the discrimination, the fact that Guatemalans are being called criminals, that there's general understanding of that. Yeah.
Okay, and yeah, Elle, did you have anything to add to that?
I just wanted to say, I was in Guatemala in February to sort of investigate how that unsafe third country agreement was playing out. And I just wanted to say, and this relates to what Blaine also said earlier, which is that there were so many policies that rolled out in like the weeks of the Trump administration. It was kind of unclear, I think, which one you would end up be putting into. And I mean, some people who came to the border were actually separated, and some family members were actually put into some policies and did get access to sort of like the regular credible, or like, you know, the more traditional credible fear process, whereas others were put in the Remain in Mexico policy. And, you know, I interviewed somebody at Honduran who was sent to Guatemala under this cooperative agreement. And, you know, his entire family is seeking asylum in the United States and had come just months before. So, I mean, to the point that, like, you know, of course, they know that it's getting harder, but I think there was a lack. You know, these things were rolled out in sort of a haphazard way, and it's not always clear how you're going to be treated, especially if you have family members in the United States already, and the push factors that Gabriella is talking about, where like you don't really have a choice, but you have to leave. So I think there's just a lot of things going on. I just wanted to mention that.
Great, thank you. I think we have two questions pending. Maybe we can, maybe three. We'll go through two. We'll go through those and then we'll wind down. One is about potential retroactivity of the rule to pending asylum cases. And Blaine, I don't know if you have any information on this, any documentation that you are aware of that would evidence how the administration has basically stopped and significantly closed off processing affirmative claims in the past few years.
Yeah, I think that I can't remember what organization put something out about the asylum office backlog not too long ago, but I haven't looked into this, so I'm not sure. But there is probably something out there on the asylum office backlogs. I don't think track data, the transactional access record clearinghouse at Syracuse, I don't think they cover asylum office, just immigration court, EOIR, but so sorry.
No, that's okay, and then the last one we've got in the queue, if anyone has any thoughts, is how the new higher standard affects the importance and deferment to testimony if there's a lack of evidence in the affirmative asylum context.
Actually, interestingly, as much as this rule touches, it doesn't speak to corroboration or credibility. Not that I want to put the ideas in anyone's head that we'd want to touch this, but testimony should still be sufficient to meet their burden. The corroboration requirements are more stringent now than they have been before. But so I think it's hard to imagine how any evidence could actually help you under this rule. Given just how restrictive it is. But I definitely think in the affirmative context that, it will require more support. But testimony alone, should still be sufficient.
Yeah, I guess the one of the issues there is with the provision that an IJ can pretermit the hearing, the whole proceeding before the applicant actually has a chance to testify. They're indicating that they could just reject the testimony without giving anyone a chance to explain any discrepancies or implausibilities in their written application. Okay, well, we're exactly at time. So thank you so much to our panelists. You all pulled this together on very short notice because, as we said, the administration gave us a really short time to respond, let alone understand the rule. So I'm really grateful to you all for being with us today, and thank you so much to all the participants. Like I said, we'll send a follow-up email through ACS with some information on comments and our technical assistance website. So thank you, everyone.